Vacant land ownership in Arizona presents a unique set of legal considerations for real estate professionals. Unlike residential or commercial property, vacant land often remains undeveloped or unmonitored for long periods, which can create opportunities for disputes over ownership or possession. One of the most important legal doctrines that can affect ownership of vacant land is adverse possession. This concept allows an individual to gain legal ownership of land that they do not hold title to if certain conditions are met and maintained over a defined period. Understanding adverse possession is critical for licensees representing buyers, sellers, or developers in Arizona because it directly impacts marketability of title, boundary disputes, and due diligence obligations. The doctrine of adverse possession in Arizona is grounded in the principles of property law and is codified in Arizona Revised Statutes, paragraph 12 to 521 through paragraph 12, 529. The concept dates back to English common law, where it was developed to encourage the productive use of land and to penalize absentee owners who neglected their property. In modern Arizona law, adverse possession serves a similar purpose. It promotes responsible land stewardship and ensures that land does not remain idle indefinitely. ARS, paragraph 12, 521. Adverse possession means an actual and visible appropriation of the land, commenced and continued under a claim of right inconsistent with and hostile to the claim of another. To successfully claim ownership through adverse possession in Arizona, the claimant must satisfy several legal requirements. These elements include actual possession, open and notorious use, hostile intent, exclusivity, and continuous possession for the statutory period. Each of these elements must be proven by clear and convincing evidence. Actual possession means that the person claiming ownership must physically occupy or make use of the property in a way that demonstrates control. This could include actions such as building a fence, cultivating crops, maintaining the land, or paying property taxes. For example, if an adjoining rancher expands a grazing fence to include part of a neighbor's vacant parcel and continues to use and maintain that portion as his own, it may satisfy the element of actual possession. Open and notorious use requires that the claimant's possession be visible and obvious to the true owner and the public. Hidden or secret use of land cannot lead to adverse possession. The law assumes that if the rightful owner has reason to know someone else is occupying the land and fails to take action, they are, in effect, allowing the possession to continue. This principle was illustrated in the Arizona Supreme Court case, Cheatham v. Vanderway, 1987. Where the court held that the claimant's cultivation and visible fencing of disputed land was sufficient to put the record owner on notice. The hostility element of adverse possession does not imply personal conflict, but rather refers to the possessor's intention to claim the property as their own, without permission from the true owner. If the use is permissive, such as through a lease or an informal agreement, the possession cannot be considered hostile. Hostility does not require ill will. Rather, it means the possessor is holding the property as an owner and not in subordination to the true owner's title. Exclusivity means that the claimant must possess the property without sharing control with the rightful owner or the general public. Occasional use by others or joint occupancy can undermine an adverse possession claim. Finally, continuous possession refers to maintaining uninterrupted control of the property for a minimum statutory period. In Arizona, under ARS, paragraph 12, 526, the general rule requires 10 years of continuous, exclusive possession. However, if the claimant has color of title, meaning they have a defective written instrument, such as an invalid deed, then the required period is reduced to 5 years, provided the claimant also pays property taxes during that time. For example, imagine a homeowner purchases a parcel based on an incorrectly drawn deed that includes a small portion of a neighboring lot. The homeowner builds a fence and maintains the property for 7 years, believing it to be theirs, while paying all taxes. Under ARS, paragraph 12-525, the homeowner could acquire ownership of that portion through adverse possession due to color of title and tax payment. While adverse possession can result in the transfer of ownership rights, it does not happen automatically. The claimant must bring a quiet title action in court under ARS, paragraph 12 to 1101, asking a judge to formally declare them the legal owner. Without such a court order, the record title remains unchanged, and the adverse possessor's rights are not legally recognized in public records. Real estate licensees must be aware of the implications of adverse possession in both due diligence and title review. When listing or selling vacant land, brokers should advise clients to obtain a recent survey and title report to identify any potential encroachments, fences, or long-term occupants. Title companies generally will not insure against claims of adverse possession unless specifically investigated and cleared. Furthermore, licensees should caution buyers purchasing large rural tracts or undeveloped parcels to inspect the land personally, as boundary disputes are common in remote areas of Arizona. Adverse possession also intersects with Arizona's constitutional principles of property rights. Article 2, Section 17 of the Arizona Constitution ensures that no person shall be deprived of property without due process of law. Therefore, courts strictly interpret adverse possession claims to ensure they are legitimate and not the result of fraud or mistake. Cases such as Spalding versus Pulio, 2009, reaffirm that adverse possession is a legal remedy of last resort, designed to protect long-term possessors acting in good faith rather than opportunistic trespassers. The policy rationale behind adverse possession remains to balance fairness and efficiency. It rewards those who make productive use of neglected land and provides certainty in ownership after the passage of time, while encouraging landowners to monitor and protect their property rights. In real property law, title refers to a lawful and regular chain of ownership tracing back to the sovereignty of the soil, meaning that each transfer of the property has been properly made and recorded, creating a clear and valid ownership history. In contrast, color of title describes a situation in which a person possesses property under a chain of transfers that appears to convey ownership but is legally defective in some way. These defects may include missing or improperly recorded documents, transfers that exist only in writing, or similar technical flaws. Importantly, color of title does not involve fraud or bad faith. Rather, it reflects an honest belief in ownership based on documentation that seems valid on its face. Color of title may also arise when possession is based on a land warrant or land scrip, accompanied by a chain of transfers to the current possessor. In Arizona, a quiet title action is a specific type of lawsuit used to establish or confirm legal ownership of real property and eliminate competing claims. It is governed by ARS, paragraph 12, 1101 to paragraph 12, 1104. The goal is to quiet any challenges, often called clouds on title, to ensure the owner has a clear, marketable title necessary for selling, refinancing, or developing the land 3 years. ARS, paragraph 12, 523, requires title or color of title, as defined above. 5 years. ARS, paragraph 12, 524, requires you to be using the land, paying all taxes, and claiming it under a recorded deed, even if that deed is void. 10 years. ARS, paragraph 12, 526, the standard squatter's rights timeline, where you have no paperwork, no title or color of title, but have occupied the land openly. Arizona Constitution, Article 2, Section 17, is the state's eminent domain, takings clause. It provides strong protections for private property owners by limiting the government's power to take or damage private property. Key points of Article 2, Section 17. Eminent domain. Private property shall not be taken or damaged for public or private use without just compensation. Compensation must be first made in money or paid into court for the owner before the taking or damage occurs. The amount of just compensation is determined by a jury, unless a jury is waived. When property is taken for a use that ultimately benefits a private party, public use must be clearly established, and whether the use is truly public is a judicial question, not a legislative one. The provision applies not only to the taking of property, but also to damage to property, offering broader protection than the federal takings clause. Why it matters. Arizona's Constitution provides greater protection to property owners than the U.S. Constitution, particularly by requiring advance payment of compensation and by allowing courts, not legislatures, to decide whether a taking is for a valid public use. Review summary. Adverse possession is a powerful but narrowly defined legal doctrine that allows an individual to acquire ownership of another's land after meeting specific statutory conditions for a prescribed period. In Arizona, claimants must prove actual, open, notorious, exclusive, hostile, and continuous possession for at least 10 years, or 5 years, with color of title and tax payment. The doctrine encourages responsible land use and protects long-term possessors while penalizing neglectful owners. Real estate professionals must be vigilant when dealing with vacant or rural land transactions, ensuring that title issues are thoroughly investigated to prevent post-closing disputes. Discussion prompts. How does adverse possession promote responsible land ownership? Answer. It incentivizes the productive use of idle land and ensures that property owners actively monitor and maintain their holdings. Why is open and notorious possession a critical requirement under Arizona law? Answer. It provides the true owner with notice and a fair opportunity to assert their ownership rights before losing the property. What role does color of title play in an adverse possession claim? Answer. It reduces the required possession period if the claimant holds a defective written document and pays property taxes on the property. Closing remarks. Adverse possession represents one of the most intriguing intersections of property law, fairness, and practicality. For Arizona real estate licensees, understanding this doctrine helps protect clients' property rights, avoid title disputes, and ensure compliance with statutory obligations. Vacant land transactions often reveal the complexities of ownership history, and a knowledgeable professional can safeguard the interests of all parties by recognizing the warning signs of potential adverse possession claims. Supporting sources and key case law. ARS, paragraph 12-521 to paragraph 12-529. Statutory Framework for Adverse Possession in Arizona, ARS, paragraph 12-523. Adverse possession with color of title and tax payment, ARS, paragraph 12-526. 10-year period for adverse possession without color of title, ARS, paragraph 12-1101. Quiet title actions, Cheatham Veers Vanderway, 718 P2D 9555, ARIZ 1987. Visibility and notoriety of use as evidence of adverse possession, Spalding v. Polio, 218 REs, 196, 2009. Reinforcement of good faith and due process principles in adverse possession claims. Arizona Constitution, Article 2, Section 17. Due process protections for property ownership.